number 19 and 20, the people of the state of New York versus Richard Leonard. Counsel?
May it please the court, if I may, can I have 2 minutes reserved for rebuttal?
Yes, you may, sir.
Thank you, Your Honor. There was no legitimate strategic reason for counsel to fail to have the jury learn that the only trial witness who claimed to have observed the charged sexual crime on the day of the event told the police that he had not seen anything specific, but merely believed that my client had done something inappropriate. By contrast, 2.5 years later at trial, the witness testified that he had seen my client's hand, in his words, on her wet vagina with his fingers down there. Could not
Counsel,
be more.
could I just stop you, because I'm a little confused about what the basis of your ineffective assistance of counsel claim is. Is it that trial counsel failed to get the police report admitted into evidence, or that trial counsel failed to confront the star witness, if you will, with statements that he made in the police report or elsewhere?
My contention, our contention below and here, is that the ineffectiveness was the failure to attempt to impeach the witness with respect to the statement, first by asking questions to the witness about the fact that at the day of the charged event, he said he had not seen anything specific, and then if the witness didn't acknowledge that, then to fail to try to get the report into evidence. This court, back in December of last year, in People v. Patterson, cited with approval 2 cases for the proposition that a police report can be used for purposes of impeachment, even though the person who gave the statement was not under a business duty.
But could counsel have thought that perhaps the fact that he even reported it immediately like that might have worked to the disadvantage of the defense
Not in the facts of this
being
case.
raised?
In this case, he didn't report it. What happened, and this is the key, is he was questioned because this witness assaulted my client on that day. And on the day, he had the greatest motive to justify his assault by saying, I assaulted Mr. Leonard because I observed him, and with specificity, sexually touching his girlfriend. He did not say that. Instead, he said, I didn't see anything specific.
No, but he did say he saw something.
He said he said, in his words, on page 91 in the record, is I did not see anything specific. I believed that Mr. Leonard was doing something inappropriate. That's extremely different than his.
Well, how different is it, though, right? He's a 17-year-old at the time, right? And he says, I didn't see anything specifically. And then later his trial testimony is, I saw her hand, but I didn't see whether there was penetration or what was really going on. I mean, isn't there some chance you do that cross-examination and what the jury concludes is it's somewhat consistent given that he's 17 years old? And you beat up on a 17-year-old on the stand too much and the jury is sympathetic?
Again, two different things. First of all, respectfully, the trial testimony that I saw a wet vagina, his hand on and his fingers down there, could not be more inconsistent than a general statement. I didn't see anything specific. I just believed he was doing something inappropriate. But more importantly, what counsel did was not merely fail to try to impeach this witness with respect to his prior inconsistent statement. He made a false argument, not supported by the record, that the witness had made a prior consistent statement. And he argued in his summation that the witness tried to, 10 days after this event, tried to justify his assault on my client by saying that he had seen something specific.
I'm sorry, counsel, that came out at the trial, the assault, the facts of the assault?
Yes, the fact of the assault came out at trial. By arguing that it was a prior consistent statement, which is not true, as opposed to making the argument it was a prior inconsistent statement, the counsel doubly hurt my client, because...
Can I just clarify, though, just Mr. Shapiro, you're going to know the record better than I am. Mr. Schifrin, you're going to know the record better than I am. Did Valley actually use the words in the police report, in the incident report, that he didn't see anything specific?
The report is unsworn, just as clear. That's the language in the report on page 91, recorded by the officer, is that he said he didn't see anything specific.
Right. The signed statement, the voluntary statement that he made, did he actually use those words? I'm a little unclear.
There's not a signed statement by Mr. There's not a signed statement that day by Mr. Valley, just so it's clear. Mr. Valley's statement to the police officers recorded in a police report. The officer had a business duty to record that report accurately. Mr. Valley was not under a duty, but that's how that report came down. There was not any statement by Mr. Valley that day with respect to what he observed.
Let me back up. 10-7-7.
Correct.
Valley signs a statement, right? You're right. And in that statement, did he use the words, he didn't see anything specific that he could be then impeached with later?
He didn't sign a statement on 10-7 with respect to what he observed. There's nothing in that statement in 10-7 about what he observed.
I'm sorry, you're saying in the voluntary statement, there was nothing about what he
In
observed?
terms of specificity?
No,
There's
but
not-
he did say, I saw Rich standing over her and doing something.
Doing something. Nothing about, again, going back to...
That was consistent with what he...
That's
the
consistent with
police
my client testified. My client's version from day one on 10-7 was that he was up there because she had, in the police report, had got sick or was cleaning up. And again, up there doing something, nothing specific, inappropriate, is very, very different, respectfully, than saying I saw a hand on a wet vagina with a finger down there. That would discredit. At the time he made that statement on 10-7, this witness was charged with assault. He had every reason to justify his assault by saying he saw a lot. He saw something very
But
bad
isn't it
happen.
possible that defense counsel was just trying to avoid highlighting the consistencies here?
Highlighting the consistencies, that's the argument by the people. The consistencies are basically irrelevant, and there was no argument that she was upstairs passed out and he was down below. There's nothing in the consistencies that in any way would support a crime. There's nothing in either the statement made by Mr. Valley on 10-7 or in the police report which would justify even charging Mr. Leonard with the sexual assault on
Well,
October 7th.
the consistency that she was passed out with her underwear and pants down, I mean, that seems consistent with an assault. I don't want to take up your time on that, though. I think you might want to move to the Molyneux.
Yep.
Yes.
With respect to Molyneux, I want to deal with the failure of counsel to seek a limiting instruction, because the key with Molyneux, of course, is that evidence of prior crimes cannot come in for propensity. But the jury doesn't know that unless they're told that. The failure of counsel to seek a limiting charge, both when the witness testified and in the closing instructions, combined with the failure to object to the use by the DA in summation of the prior event, creates the real danger that the jury was considering the prior uncharged crime for propensity, especially given the similarity.
So you're going after Molyneux on ineffective assistance of counsel?
That's raised in point 3D.
Also, you're going on the Molyneux substantive ruling as well.
I raised that also, but I'm focusing now because the totality representation between the failure to have the jury ever learn of the prior inconsistent statement, the failure to have any...
Can I ask you just quickly about whether the people ever advanced a specific purpose for using that Molyneux evidence?
Yes, they did. They talked about showing intent, motive,
Motive to get her drunk, intent?
Yes,
Okay.
yes.
And is there really any distinction between what they were saying that they're, maybe I should ask them, never mind.
Thank you, Mr. Schifrin. Counsel?
Good afternoon. May it please the court. Robert Shoemaker for the people. This is not a case of ineffectiveness. This is a case of disagreement with counsel's trial strategy, and the defendant has not established that trial counsel's failure to utilize these prior statements from the witness demonstrated a lack of strategy.
What about the Molyneux failure to ask for a limiting instruction?
So that could also have been part of his strategy. His strategy, essentially, what we see in the opening and the closing, the opening at page 229 of the appendix, the closing at 362 to 363, is that the victim and her then boyfriend were locked into these allegations. He wanted to show the whole thing, defense counsel wanted to show the whole thing was a fabrication. So as for looking at the Molyneux in the context of an ineffectiveness claim, defense counsel didn't want to draw attention to these 2005 allegations because, again, his defense strategy was that these 2005 events could never have occurred. The defendant actually took the stand and said he wasn't even living there at the time. So I think...
But don't you think that those two, or her testimony about the prior events was like the elephant in the room in this whole case? I mean, no, you know, she doesn't remember anything, and you know, he's got some credibility issues. So how could that not have been, you know, a serious issue?
Well, it's very strong Molyneux evidence that we sought to use and that I argue was properly used. Defense counsel had the choice to address it in his summation or address it by asking the court to give a limiting instruction, or defense counsel had the option to not address it and just argue that this is all a fabrication. So
But let's take a step back. Let's go to the substantive issue itself. Forget about ineffective assistance of counsel.
Sure.
For Molyneux to go in there, it has to be linked up with some material issue that's relevant in the case. Not in the 2005 case, but in the present case. What material issue is it relevant to in this case?
Sure. So it's material because it shows the motive for serving or over-serving the alcohol, the unlawful dealing. The motive behind that, why did defendant want to get the victim
I
drunk?
can't
Isn't
say
that-
that I see that at all. I would have thought maybe, I thought you really relied on background and completing the narrative, and I thought that's what the court relied on.
Well, there's three reasons. So one is the motive. This is what the Fourth Department decided. Motive, what I just said. Intent, as far as the sexual gratification. Why is he actually doing this? And sexual gratification was something that we had to prove at trial. And the background, to completing the narrative. And those are the three reasons.
But doesn't the crime itself suggest both the first two, the motive and the intent?
The crime itself can suggest those. Defendant's, I guess his defense was that this was a mistake where he was placed and everything. His defense was that he was cleaning up vomit. So our burden to prove this case beyond a reasonable doubt, in order to do that, we can use any evidence that is admissible. In this case, the Molyneux
The
evidence.
mistake, I'm sorry, that he was cleaning up vomit, what mistake was that? That he never said, his position was, I didn't touch her. I never did anything, so what's the mistake?
I guess the mistake in interpreting where he's located, like the fact that he's kneeling beside her while she's passed out on the couch. The Molyneux evidence helps to show, from the people's perspective, the Molyneux evidence shows that he wasn't there cleaning up vomit. He was there, his intent was for sexual gratification. He had gotten her drunk.
It seems to be.
But isn't that the whole point? All you're arguing is, look, he did that before, so it must be why he's doing it now. I mean, that's exactly what Molyneux is set up not to allow you to do.
Well, when it's relevant for those reasons, that is what it allows you to do. It's relevant to show his motive, it's relevant to show his
He
intent.
committed the same
especially-
crime before. You're saying that it's showing his intent to commit the same crime again. That's not allowed under Molyneux.
If it's the intent, within his intent is that he's doing this for sexual gratification.
See, these are always difficult, you know, the Molyneux issues are difficult and they're complicated, I recognize that, but what I'm concerned with sometimes is that it appears like pure propensity, and then quite often the people then rely on completing the narrative or background, and most times that makes some sense, but I'm struggling with it here because it seems if it applies here without an identifiable element in this crime, as opposed to some other action that it links up to, then the exception would swallow the rule. That's why I'm addressing the questions that way to you.
And I just think in this case, the Fourth Department correctly held that they explained that in their view and in my view, I agree with the Fourth Department decision that the motive was there. This helps to show motive for the alcohol. It helps to show the intent as far as sexual gratification, and it helps to show completing the narrative background, the relationship between these two individuals.
What is it about their relationship that relates to this crime? Can you articulate that? Because I just don't really understand. It's been said, but I just don't understand what it is. I mean, yeah. Go ahead.
In my view, it's the sexual gratification. It's the fact that he is touching her for his own sexual gratification. In 2005...
Again, doesn't that just say he did it in 2005, therefore he must also be doing it now? To me, I don't understand how that relates to their relationship.
For purposes of sexual gratification.
I
That he was
understand.
breathing, in 2005, the testimony is that he was breathing heavily. And in this particular case, I guess
So
I
you're
don't
saying
know another way to put
that
it.
the completing the narrative or explaining the relationship is the same thing as showing intent? It seems to me you're conflating those two
I think the facts of the case are what conflate the two, that his relationship with her, going back to 2005, also shows his intent in this particular case, which was sexual
Counsel,
gratification.
did
for his own
the
part.
trial court do any balancing here? I didn't see anything in the trial court's decision that said that it weighed whether the probative value of this evidence outweighed the prejudicial value of this evidence, and that's part of the Molyneux equation, isn't it?
So you can see the court did, even if he didn't explicitly use those words, you can see the people originally asked for three, to get into 3 areas on Molyneux. The court only allowed one of the 3, the most recent of the 3. That there, I would argue, is an exercise of discretion. And as we're looking at this case for an abuse of discretion, the fact that the court only allowed 1 out of the 3 shows that the court exercises discretion.
But does that show that the court analyzed this particular prior act in terms of its probative versus prejudicial value, or just said, you know, how does that tell us what the court considered?
I think it does show that the court considered that, and we also have, there's a question and answer between the court and the prosecutor about kind of what I'm saying right now. Well, why she needs to get into this prior event, and the prosecutor says to show sexual gratification. And the
It sounds
court,
like,
I
you
think
know,
the
it
court
sounds-
took overnight to,
But it sounds like your rule is basically any time there's a prior sexual bad act, it gets in to show sexual gratification. I share some of the uncertainty, I think, is being demonstrated by my colleague's questioning.
Well, it's
Where is this line? Because Molyneux has a line, and I'm not seeing much of a line in what you're promoting here as the rule.
well, the line, I mean, the line is, first it has to be relevant, and then it has to be more probative than prejudicial. The line is, we are looking at it now, is did the court abuse its discretion in this particular case in deciding those 2 factors in favor of the people to use this evidence?
Yes, but you're saying it shows sexual gratification because he's touched her in the past to sexually gratify himself, so he's touching her here to sexually gratify himself. Again, that sounds like propensity. It then sounds like it always gets in. Doesn't sound like an exception, it sounds like you've made it the rule.
Well, I mean, it wouldn't always get in. It would get in if it were more probative than prejudicial in the eyes of the trial court, and if it did show any of the Molyneux exceptions.
And I'm struggling still with how it's more probative than prejudicial when these are the exact same charges that were presented to the grand jury. And am I correct in reading the record that no true bill was found on these 2 charges in 2005?
So they weren't asked to indict a sex abuse charge for 2005. You are correct that there was no true bill, but they weren't asked. I don't know if you have that part of the grand jury list, but they were not. They were only asked to indict endangering the welfare, which I think they did, but was later dismissed because of the age of the victim, and then the 2 charges that are in this indictment. I would, unless there are more questions on Molyneux, I'd like to briefly touch just on the general ineffectiveness. I know there was a question about the consistency or inconsistency of the statements. I would argue they're actually a lot more consistent, the prior statement and the testimony at trial. The prior statement at page 91 of the appendix is that Evie didn't see anything specific. At trial, he actually testified at page 249, I can just see his hand like touching her, couldn't specifically see his fingers. So the same word is used, couldn't specifically see where things were. And as I said before, the defense counsel's strategy was that the victim and her then boyfriend were locked in almost as a retaliation. They were locked into this testimony because of the assault charges. His strategy was made clear in his opening and his closing, and this was a matter of strategy, not a matter of ineffective assistance.
Thank you, counsel. Mr. Schifrin?
Very briefly, with respect to the Molyneux issue, first of all, People v. Huddy, this court held that prior sex acts of a similar nature generally don't come in unless it fits with an exception. But I was arguing before and argue again, to the extent that the court below might have been correct with respect to this Molyneux holding, it would only be correct if the jury was specifically instructed that they couldn't consider it for purposes of propensity. That was the duty of defense counsel. The respondent's arguments today is that counsel didn't want to emphasize, and draw attention to the 2005 charge, which is odd since the majority of counsel's summation dealt with the uncharged 2005 event, not the charged 2007 event. In any event, having a judge instruct a jury like the limits of the testimony is in no way inconsistent with a defense attorney arguing that the uncharged events didn't occur. There are two ways to benefit. And finally, by the way, the confusion that's created is best evidenced by the certificate of conviction, which on page 18 in the record, which shows a conviction for 2005 sex assault. Even the court clerk thought this was a case about the 2005 assault, not the 2007 assault. With respect to the argument that counsel made, he was locked in. Again, that was an argument that was a prior consistent statement, which isn't true, and it was weaker than the correct argument that when he could have and should have had his best chance to explain his behavior, he didn't, and only now, years later, which is why, in answer to the question that was asked, my client was not charged in 2007 with this crime. It was only in 2009, 2 years later, for the first time, did this witness ever come forward and make the allegations that he observed that in 2007. And that when he was indicted 2 years after that event, there was never a felony complaint or any other charge of a 2000 sex offense because there wasn't sufficient evidence, because what he told the police in 2007 was not sufficient to support the charge, which is why the counsel needed to have the jury learn that.
Thank you, counsel.